Welcome back. I'm Ryan Smith. Casey Anthony pleaded the Fifth Amendment in this case and refused to answer many of the questions posed to her during her deposition. Now Zenaida Gonzalez's attorneys are going to ask the judge to force Casey Anthony to answer their questions. You see, they say this video diary posted on YouTube is evidence that she's not afraid of incriminating herself.
Silly is saying that I have a computer and a camera and a phone. Granted, I wouldn't have the phone without. And I've actually now paid for my own computer.
Casey's criminal defense attorney, Cheney Mason, told us Anthony did not upload the video to YouTube or authorize its release. He says someone obtained the footage illegally. So that promises to be a big argument today. Joining me now to talk this over a little bit, civil attorney Jeffrey Shapiro, in-session correspondent Beth Garris, and in-session legal analyst and contributor Sonny Hostin. Hey, Jeff, let me start with you really quickly on something I just talked to Matt Morgan about. He mentioned the standard we talked about in terms of proving defamation, that the comments had to be directed towards Zenaida Gonzalez. And he mentioned that recklessness in mentioning her name was enough to meet that malice standard. What do you think about that?
Well, that's not what the Florida Supreme Court said. I think he better read that decision before he goes to court in 20 minutes, or he's going to be in a lot of trouble. As I read to you earlier, they show you have to show that the primary motive is making the statement was the intent of injuring the reputation of the plaintiff. Making a reckless statement isn't anywhere close to what the standard is. It has to be an intentional false statement with the intent of harming the reputation of the person. So he better regroup on that one.
All right. You know what, Beth? I want to bring you in on this.